Good morning, everyone. My name is George Pangis. I'm an attorney at the Pangis Law Firm. Quick background on me. I have offices in Englewood, New Jersey, and in White Plains, New York. I do both sides of the river. My areas of practice include real estate, of course, but also, as you'll see with the topics that we're going to be discussing here, a lot of bankruptcy and a lot of commercial litigation. And when I say bankruptcy, that's really an umbrella term for things that include foreclosure, defense, and general insolvency law. But it's weird, this unique trilogy of key practice areas has sort of shown me how much over the years overlap there is between them. Very often you'll find an attorney who does real estate and that's all they do. They do real estate closings, usually the conventional ones, and that's about it. And if a little bit of some situation deviates from the norm, they're not always prepared for the what if. Within my shop, it's one-stop shopping because, again, I have a lot of experience in these other practice areas that we're going to discuss today. And the reason we're doing this Power Hour today, which I've entitled Real Estate Outliers, Unconventional Ways of Buying and Selling a Home, is because everybody here who's a realtor certainly knows how to buy or sell a home from the very generic process. You have a buyer, you have a seller, there's a mortgage, clear title, great, let's go to closing. But there's a lot of situations that may pop up that deviate from that. And I'm not going to pretend to make everyone here an expert in these areas in the next hour, but I will at least give you a familiarity with the concepts and let you know that these exist. So if you encounter in talking to a client a unique situation that deviates from the norm, at least in the back of your head you say, hey, I remember hearing someone once talk about this. Maybe there is a way out here we can still buy or sell this property. So if anyone has any questions during the presentation, I encourage you to ask them. I will stay around for as long as needed afterwards, though. So if anyone has, let's say, a hypothetical or you want to walk me through a case that you're dealing with, please do save that for the end. But if you have any questions about the presentation while we're going, I do encourage you to ask. So there's going to be 7 big topic areas that we're going to be discussing here today. And again, I'm not going to make you experts on all of them, or any of them even, but I want some familiarity on foreclosure. What happens if you have someone that comes to you in a foreclosure situation or about to be in a foreclosure situation, they want to sell their home. Bankruptcy, how we can use bankruptcy to sell a home, or can you buy a home in bankruptcy. REO, real estate owned property. Short sales, how the New Jersey Bulk Sales Act affects your ability to sell a home and when it's invoked. Buying a HUD house, and at the end 1031 like-kind exchanges. So again, these are all things that deviate from the standard practice that that we do on a day-to-day basis. And we're starting with foreclosure. What is a foreclosure? Very simply, it's a creditor's attempt to obtain title to real property or in partial or complete satisfaction of an outstanding debt obligation that's owed by the homeowner. Now, there are several different types of creditors who can foreclose. Obviously, a bank foreclosing on a mortgage is the most common one, right? But there are other ones as well. It can be a tax lien. If a tax lien has been sold by a municipality, the tax lien holder can do a foreclosure, and it's a different process when that happens, with different rights of redemption and different timing on redemption. If there's a condo, and the condo association has outstanding fees, they can foreclose, and they can foreclose out the mortgage. So it's important to know exactly who's foreclosing here, and in some cases, you can have just a simple judgment, a simple money judgment. Someone owed money to a dentist, a doctor, credit card debt, get a lien on that property, theoretically they could foreclose depending on the situation. And it's important to know who is doing the foreclosing so that we know how to approach it. So, whose interest on a property can be foreclosed? Well, obviously any titled homeowner, right? You take a loan out, get a mortgage on that property, default on the mortgage, your interest can be foreclosed out. But even a non-titled occupant of the house, someone with possessory interest, husband and wife live together in the house, but only the husband owns the house. Maybe he owned it before they got married. The wife lives there. She has a possessory interest in the house. She has to be named in the foreclosure. She has rights to live in that property that have to be foreclosed out. Spouse, partner, cohabitant, and any subordinate lien holder on the property can be foreclosed. You have 2 mortgages on the property. The primary mortgage is likely the one that's doing the foreclosure, has to foreclose out the rights of the subordinate lien holder. Or if you have a simple money judgment on the back end, their rights have to be foreclosed out as well. Now there's someone that's not listed on there, and we're going to talk about the role in a minute, but renters. Renters are not on there. Renters are not subject to foreclosure. And how we treat renters in a foreclosure situation is very important if we're representing someone who's buying or thinking of buying a foreclosed house. So, here's a question that someone with 20-odd years in this industry had asked me recently because a bank had gone to her and said, we're about to start foreclosure proceedings on a house. Therefore, you are not allowed to sell the house. Is that true? No, of course it's not true. You can absolutely sell a house if the lender is preparing to initiate foreclosure proceedings. But it's one of those things that people just don't know sometimes, right? You don't deal with it every day. So when does the right to sell a house actually expire? Only after delivery of the deed by the sheriff. For that to happen, you've gone through an entire foreclosure process. The bank or their foreclosing party's gotten a judgment. They have had a sheriff sale. The time to redeem has expired. And then the sheriff delivers the deed to whoever the successful purchaser was at sale. That is a long way down the road from the bank telling you, hey, we're going to foreclose, you can't sell the house. So there's a lot of opportunity here. Now there could be some questions about whether or not you can convey good title in some of those situations on the sale, but put that aside for the moment. The ability to market and sell a property is strictly and exclusively in the hands of the homeowner until the actual deed has been delivered by the sheriff, because until then, the homeowner is still the title homeowner. So, what do you do when a client's property is about to go into foreclosure, goes into foreclosure, or they come to you and they're already in foreclosure? Well, the first thing you do is you get an attorney quick. And I don't say that to be cute. I mean that because they're going to need a lot of holistic advice about how to deal with their situation. Every single person is going to be unique. I don't need to tell you that. All your clients are different. They have different needs, different financial situations. How you approach their situation is also going to be unique, and you want to get as much time with an attorney as possible. One of the reasons for that is whether or not the foreclosure will be defended directly directs whether you will have 8 months to sell this house or 18 to 24 months. An uncontested foreclosure, residential foreclosure in New Jersey right now takes about 8 months, beginning to end, if the bank is being aggressive, if their attorneys are on keeping on track with certain guidelines, and if all the paperwork is in order. Now those are three big ifs, and you often don't find those three things all sort of hitting at the same time. But if they do, you have basically 8 months. And if you have someone who is looking to sell a house, that's the window you have. If you have someone come in and muck up the works a little bit, an attorney who knows what they're doing, and can file an answer to the foreclosure complaint, can request mediation, can extend that deadline, you've now got 18 to 24 months. So, I mean, you can imagine if you're going into, let's say, September, and someone comes to you with a foreclosure, you're about to go into the not busy season, right? Not a great season to sell. So why would you run most of that 8 months out in the winter and in the very early spring when you could have an entire summer season just by contesting a foreclosure? An attorney can help evaluate other options, such as a loan modification or a refinance on the loan. Now, I throw refinance in there. Realistically, if someone's in foreclosure, you're probably not going to get a refinance. It's possible, but it's unlikely. You have a defaulted loan, and there's probably a lis pendens filed already with the property, so it's unlikely a lender is going to refi. But what you can do with the loan modification is you can reinstate the loan. Brings the loan current, effectively gives the borrower a new loan, which throws out the entire foreclosure. And that buys you a whole lot of time to market and sell a property. But it's very important to listing agents specifically here. Do not rush. If someone comes to you and says, hey, I'm about to go into foreclosure, I'm in foreclosure, we need to get rid of the house, don't just rush that property onto the MLS, because by doing so, you may have lost the borrower their right to seek a loan modification. Every lender that I know has a 6-month look back to see if that property was listed for sale or is listed for sale. And if it was or is, they will not modify that loan. Because in their eyes, you do not want to keep that property. You're already trying to get rid of it. And that's going to be on every loan modification application that you will see. So, again, we want to best serve our clients. I'm not saying we can't try and sell the property, but meet with the attorney, sit down, look holistically at the client's needs, and determine whether a modification should be at least attempted, depending on the timing of the foreclosure. If you rush them into a listing, you may lose their modification ability. You got to know who's foreclosing here. The process, the time frames, and determination of rights of the homeowner differ, depending on the type of creditor foreclosing. So, for example, I said before about a bank foreclosure where you get the default judgment, and then you go to sale, and then there's a redemption period, and then there's delivery of the deed. That's for a bank. If you're a tax sale foreclosure, that is not what happens in New Jersey. When they get their final judgment, that's it. Title now vests with the lien holder. There is no sheriff sale. There is no redemption period. There is no delivery of a deed that buys you a little extra time. That property is lost. So if we hear years. Was there a question?
I just, so then who owns it?
Who owns it? The tax lien holder.
Tax lien holder.
Tax lien holder. When they get default judgment, title vests. They don't need to do a sale. So it's one of those things that knowing exactly who you're dealing with is vitally important in determining the time frame and the rights of the borrower. Now the opportunity also exists for an individual, and this is more for the buyer situation. If you have a buyer, let's say a vulture capitalist is the term that's often used, people that want to look for properties that are, you know, either underwater or depressed in some way, they may walk in, hard money lender, and buy the note. You can buy the note from the bank, and then you step in the bank's shoes and you can foreclose out everyone else and buy the property. That is an option. If you have the right kind of client looking at the right kind of property, that property is in foreclosure, we can evaluate the situation depending on where the foreclosure is. Maybe you want the bank to finish it off. Maybe you want to finish it off yourself, but you might be able to buy that note at a discount from the bank if your buyer is willing and able to take on the remaining risks of foreclosure, meaning you have to pay to complete the foreclosure and all of the fallout from foreclosure. Now, one of those fallouts could, of course, be who's living on the property. I've said before that renters cannot have their rights foreclosed, okay? If you have a renter on the property, whoever's foreclosing has to notice the renter of the foreclosure process. When the foreclosure has been completed, you have to let the renter know within 10 days that the property has been foreclosed. If they were on a month-to-month rental lease at that point, you have to give them 90 days notice before you can evict them. If they were in the midst of a long-term lease, the buyer of the property has to honor that lease. So, what you will find sometimes is a recalcitrant borrower who's about to get foreclosed, wants to stick it to the bank and give someone a 1 or 2 year lease right before they walk out the door. Foreclosing party is bound by that lease. And you can give the 90-day notice within 90 days of expiration of that lease, but again, it differs from a normal month-to-month tenancy where they basically get a 30-day window to go. So there are certainly rights that the renter has, and that's one of the risks, especially if you have someone looking to buy the note from the foreclosing bank, that's what they're taking on. That's the risk they take on.
George, one quick question. When
Yes.
you have, you said these vulture buyers or whatever,
Yes.
if they buy the tax lien, so then they can foreclose on the property, but then they have to pay the bank, how does that? Then they basically pay the bank whatever is owed on the thing, or?
Great question. The question was, if anyone didn't hear it, how does the situation differ if the vulture capitalist, as I referred to them, buys the tax lien? There are very special investors who usually go out and buy tax sale liens from municipality. Municipality usually lets it go about 2 years before they offer the lien for sale, and people target certain properties and buy them. There's a couple of advantages to doing so. One is you get an 18% interest rate of return. The second thing is you have a higher priority than the mortgage company on that property. So the mortgage company will not foreclose you out. You will foreclose out the mortgage on the property. And that's why we often find in situations where we have a defaulting borrower that the mortgage company starts advancing for taxes. Why are they doing that? Not out of the kindness of their hearts. It's self-preservation. Because they realize that that's one of the few entities that can throw them out of a first mortgage position. So the tax authority, or the tax lien holder, can either do a foreclosure of their own and foreclose out everyone beneath them, or they can get redeemed at any time. Someone can step up, pay the 18% interest and whatever's due and owing, and cash them out. Is there another question back there? Yes.
Is there a way for a realtor who's helping someone find a rental, make sure they don't get into a house that someone's being foreclosed on?
Great question. The question was, if you're working with a renter, how do we make sure they're not walking into a situation like that? Foreclosures are public record. And in the last year, I think now every county in New Jersey, but certainly every county in North Jersey, has online filing. So you can search on the New Jersey Court website for either the seller's name or the property address and see if you get any hits. And if a foreclosure complaint has been filed, it will be on there. Now, if a foreclosure complaint was filed maybe 2 or 3 years ago and the case is lingering for some reason, at that point what you may want to do, and this is a theme that will come up later, is work with the title company. Everyone here who's a realtor has an in-house title company. If you don't, then you can talk to Chris at the end from Simplicity Title over here and take his card, because they're a great title company. And what you would do is you could get a title rundown for the house. Give the property address and see what's out there, because if you get that abstract back, you will find out if there's any foreclosure proceedings that have been filed. So what is bankruptcy? Well, bankruptcy is a federal law. It allows debtors to liquidate or reorganize their debts. It is also a collective creditor remedy. That means you deal with all of the creditors of a particular debtor or series of debtors in one forum, right? In today's digital age especially, if you have 3 credit cards, the odds are the banks are located somewhere. One's in Delaware, one's in Minneapolis, and one's in Texas. So if you default on all 3 credit cards, do you want to be going to Minneapolis and Austin and somewhere in Delaware to fight this? No. In bankruptcy court, you have one forum, and everybody deals with the case there. Every creditor is treated identically within their classification of creditors. There are different chapters of bankruptcy, and these chapters are intended to address the different needs that different debtors have. So for example, there's a special chapter of bankruptcy for municipalities. When the city of Detroit filed bankruptcy a couple of years ago, that's going to be treated a lot differently than if I file for bankruptcy, okay? The 3 primary consumer bankruptcies are Chapter 7, Chapter 11, and Chapter 13. Now that could vary a little bit also. There's Chapter 12 for fishermen and farmers and stuff, but by and large, these are the 3 most common. And when to invoke them depends specifically on what the needs are. A Chapter 7 is a liquidation. It can be filed by an individual or a corporate entity, and the idea is you're not trying to protect an asset, you're either closing up shop or basically surrendering, with some exception, your assets and liquidating your debts. That mostly allows you to discharge unsecured debt, credit card debt, things of that nature. A Chapter 11 is what can be handled 2 ways. It can be a reorganization. When A&P filed, they filed Chapter 11. Right? They're trying to reorganize their debt in a very big way. It can be filed by corporate entities or high-income individuals. If your assets or liabilities are above a certain threshold number, then you have to go to a Chapter 11 if you're trying to reorganize. Okay? Chapter 11 can also be a structured liquidation, but for purposes of today, let's just consider it the reorganization. So you have your high-income, high-asset people, and you have corporate entities. The Chapter 13 is sort of a hybrid of the 2. Chapter 13 is consumer-only. Corporate entities cannot file a Chapter 13, but an individual or a family can file a Chapter 13 to reorganize their debt. Your garden variety Chapter 13 is someone was out of work for a bit and fell behind on the mortgage. They want to keep the house, so they offer a repayment plan to the bankruptcy trustee to cure and reinstate the mortgage. So how can bankruptcy help you buy or sell a house? Well, a couple different ways. First, by operation of law, this is one of the best selling points that bankruptcy offers, there is what's called the automatic stay. When someone files a bankruptcy, they have to do nothing else. If they've never filed before specifically, they automatically have the stay of any and all collection efforts against them. That includes a foreclosure. So, we talked a few minutes back about someone comes to you, a house is going into foreclosure, maybe they're about to lose it to sheriff's sale. In my 15 years of experience, I can tell you that most people don't like dealing with their financial issues until the very, very latest possible moment. At the 11th hour, they'll walk in on a Friday morning and say, my house is being foreclosed Monday, can you help me? That happens more than I care to admit. But the automatic stay of a bankruptcy would stop that foreclosure. It would stop all collection efforts while the bankruptcy is pending. So if you ever have a situation where someone they come into you, they say, listen, I've got a house, I've got equity, I want my kids to finish the school year, I need to buy a couple of months, what can we do, what can we do? A bankruptcy could be an option because it stops everything dead in its tracks. Then this buys time for your client also to market and sell the home because you can buy or sell a property in the bankruptcy. So, in the bankruptcy, specifically Chapters 11 and 13, if you are a debtor, your plan of reorganization could be specifically that I will market and sell my property and pay off my liens through that sale. So if somebody comes to you and they have that 11th hour need, we have a way to stop a sale or to stop a terrible situation. Maybe there's going to be a bank levy or a garnishment of wage or something like that, and still allow them to realize the equity in their home. Okay? Usually these days, it's about a 6-month window in a Chapter 13. 11s are a different animal, but generally speaking, most of our clients would be Chapter 13s, and the trustee there generally gives about 6 months to market and sell a property. So if we think about it too, if they come to you in, let's say, December or January when it's not a great season, you're probably not going to flip that house quickly, buying 6 months gets you into the busy season and gives them a chance. And that 6 months, if you have a contract in place or a potential buyer, could give you a better opportunity to market and sell the property. Yes?
What happens to their credit after the bankruptcy?
Great question. The question was, what happens to their credit after the bankruptcy? I'm going to get to that in 1 second. Hold that thought, okay? You will get also your commissions paid if it's sold in a bankruptcy. You're not forgiving anything here, okay? You don't have to give that up. What we do is we would make an application to the bankruptcy court, it's a pro forma motion, that appoints you as the broker of record for that particular seller, and you have the listing agreement attached as an exhibit, and your regular, I'm assuming it's going to be 5% these days, but whatever the percentage you've agreed upon is, and that will be there, and that will be enforced, and you would be paid at closing. So, in a bankruptcy, a client can reorganize their debts, or they can relieve themselves of some of their debt obligation, making them better able to buy a new property. Okay, so going back to the question a couple of moments ago of how will a bankruptcy affect the credit. Okay, a client with equity in a home can realize some or all of that equity. If you have $50,000, $60,000, $100,000 of equity, but you lost your job, if you're going to lose that house to foreclosure, you're not going to get that equity back. But if you can cure and reinstate that mortgage in a bankruptcy, or more importantly, if you can sell the property through the bankruptcy, but protect yourself from the foreclosure in the meantime, you can still realize that equity. In some circumstances, the client can create equity and avoid a short sale. Well, how do we do that? We're going to talk about short sales in a few minutes, but we all know the basic idea of a short sale is more money is owed than what is available through the net proceeds of the sale. A lot of times what we find, and I'm sure we've all bumped into this, is the client doesn't take into consideration the fact that there may be judgments, money judgments on the back end, which are the reason for the short sale. They say, well, I have a mortgage, but I know it's about the property of the house, we can pay that off. And they don't realize until the title rundown is done, oh yeah, but there's also 5 separate judgments out there, each at $25,000, and there goes your equity. And all of a sudden it's a short sale, right? In a bankruptcy, you can discharge that unsecured debt obligation. So if something was, if you had a house that was worth $500, and you had $450 in secured liens, and you thought you had $50,000 in equity, but you have $100,000 worth of judgments against you out there, all of a sudden that's a short sale situation outside of a bankruptcy. You can't sell that unless you get that debt compromised in some way. But in a bankruptcy, they can discharge that unsecured debt and walk out of the back end of the bankruptcy with a house that still has its $50,000 in equity. Now you can sell it without making it a short sale. Question?
If you're bringing a buyer, how would your buyer, how would you know if there were these, how would you find out, let's say that the seller doesn't know that they have all these judgments. How would you know if you're bringing a buyer to a house that's, you're going to be able to move forward on?
Great question. The question was, if you're representing a buyer, how do you walk into a situation and know whether or not it's going to be a short sale effectively if it wasn't advertised as such? Short answer is, from the buyer's perspective, you won't. I'm going to talk in a couple minutes about what I think sellers, listing agents should do, as preparation to avoid that situation. But from the buyer's perspective, you're not going to know until the title rundown is done. And I think we've all bumped into that situation. Houses either don't close or don't close on time because you're trying to compromise stuff at the 11th hour. Okay? Is there a question?
When you're talking about the bankruptcy, just say if you're filing it in New Jersey, is it only good for New Jersey? Or like just say you were bankrupt in New Jersey but you moved to Florida?
Gotcha. Question. Great question. Question for those who didn't hear it was, if you file in New Jersey, how does that affect you if you go somewhere else? Bankruptcy is a federal law. So you file in New Jersey, it doesn't matter where the debts are, it doesn't matter where you go to, you are protected. Okay. And as a general rule, that actually brings up something. Everything I'm talking about here today, even though I work on both sides of the river, I'm going to be talking about New Jersey statutes and New Jersey customs. New York, for those anyone here who does New York, a lot of these are similar concepts. Bankruptcy is federal, so it would be the same. But they would vary slightly. So everything today has a New Jersey focus on it. You can discharge an underlying debt and remove a judgment lien in a Chapter 7, Chapter 11, or Chapter 13 under New Jersey law. If somebody actually had a judgment lien, let's say the creditor who had the medical debt or the credit card debt actually levied a lien on the property. So there's a lien on the property, not just a judgment, an actual lien. 1 year after discharge, you can get that lien removed of record. And again, that also allows you to get free and clear title. So there are a number of ways that you can use the bankruptcy process to convey that title free and clear and create some equity. Now, one of the more powerful parts of bankruptcy are these two unique concepts here. These are only available in Chapter 13 or Chapter 11. You can strip off or you can cram down some mortgages. What does that mean? You have a house, say it's your primary residence, it's worth $400,000. The first mortgage is $425,000. You have a second mortgage on it for another $100,000. In a bankruptcy, you can completely strip off that second mortgage. If it's an investment property in New Jersey, anything other than a primary residence, let's change the numbers a little bit. The house is worth $500,000. You have a first mortgage of $450,000, second mortgage of $100,000. So there's that $50,000 gap, let's say. of what the equity would be. You can cram down that second mortgage from $100,000 to a $50,000 secured lien. What does that do for you? It takes a property that's underwater and suddenly brings you to a break-even point. Now you are not listing a short sale anymore. If that debtor completes the bankruptcy, Chapter 13, and I will be clear, the Chapter 13 is a 3 to 5 year reorganization plan, okay? You can sell, however, to expedite that plan. So if your proposed plan says cram down the second mortgage and I'm going to pay off that $50,000 secured part, you can still sell that property in the bankruptcy. And it's not a short sale because you're paying off those liens. And you're stripping off everything else that would be unsecured. It's a really, really powerful tool. The numbers have to work and the situation has to work, but these two situations can be very, very valuable to somebody who wants to avoid a short sale and, and still walk away without having the property be foreclosed. And again, you will have your commissions paid, I will have my fee paid, and the title company will get their fees paid by the buyer, of course, so, outside of the bankruptcy. Everybody will get paid. Realty transfer fee still has to get paid, can't close without that. Everything's going to be approved by the bankruptcy court.
How can you cram down the second mortgage?
The question was, how can you cram down the second mortgage? The idea is that under New Jersey bankruptcy law, if it's not your primary residence, because a primary residence you can't cram down partially, we call it partially undersecured property. The bankruptcy code allows you to do that. As simple as that. The
It
bankruptcy
has
code.
to be filed for bankruptcy in order to do that.
Yes. This is only a bankruptcy option. This is the power of the bankruptcy court that allows for this, correct.
So does the person that's owed the money get paid, or it just gets?
The rest of it is discharge. A discharge is a legal term for no longer have a legal obligation to pay you.
That's what bankruptcy is.
So,
$50,000.
so the $50,000, my hypothetical, there was a $100,000 second mortgage, $50,000 of it was hypothetically secured, $50,000 was unsecured, that $50,000 unsecured goes away. Now, if for some reason the sale price allows for some distribution to unsecured creditors, they would get paid a piece of that $50,000, but the rest is discharge. The homeowner sells the house free and clear to your happy buyers, and the homeowner walks away from that $50,000 remaining unsecured portion.
You said that was only on,
Go ahead.
you said that was only on a second house?
Any investment property on a cram down or a cross-collateralized business loan, but if it's your primary residence, that's really accepted. Primary residence, you can't cram down, you can always strip off. Anything that's not your primary residence, you can do either or depending on the situation.
For primary residence, the home equity, a second loan, a second mortgage, that can't be crammed down either, right?
No, can't be crammed, that can be stripped off. If it's completely underwater, you can strip it off, but you can't do it. A cram down is basically a partial. A strip off is the entire value of that loan is underwater, it's undersecured. That whole lien can be removed, but you can only cram down, which is a partial reclassification on a second mortgage. Excuse me, on a second property, not a primary residence. There were some questions about
I
that.
think I'm just confusing the bankruptcy with personal debt.
Okay.
You know how like if you did something written off, like say from a credit card company and they write off $800, then at the end of the year they can give you a form and you have, and it's considered like a gift and you still have to pay taxes on that? There's nothing like that in bankruptcy.
Great question. The question was, if you have a creditor who writes off a debt and they can 1099 you at the end of the year, Merry Christmas, here's a 1099 for the debt I wrote off, right? It happens. American Express does that more than most if we're dealing with credit card companies. The question is, does bankruptcy have that? Not only does bankruptcy not have that, but you can discharge the obligation on that 1099.
Oh, wow.
Question back there, yes.
Okay, that takes me back to my credit question. Can they then buy another property?
I was just about to get there. Yes. I hadn't forgotten about you, I swear. That
Okay,
was just lined up on your
just-
presentation.
I know.
I'm sorry.
People go into bankruptcy versus a short sale.
The question is, why don't more people go into bankruptcy versus short sale? A lot of reasons. One of them is, let's be candid, there's a stigma with bankruptcy. There is a stigma. People don't want to file for bankruptcy, right? They don't want their creditors to find out. Bankruptcy, every creditor would know about it, right? You have to list all of your creditors. So let's say some family members gave you a personal loan. They're going to know you filed for bankruptcy because they're noticed on it. Some people just prefer to see if they can do a short sale and walk away. And listen, if the house is the only asset, maybe it's not worth doing a bankruptcy for them.
At what point, is it that people don't think to go that route, or by the time they think of that route, it's too far? I mean, if a realtor isn't brought in until you're well down the road
Yes.
would be saying to them, have you considered bankruptcy? You know, I just don't, you know, like, who is there to help people to think of these things?
Well, that's what, who's here to help people think
All
about these
right,
options? That's why we're here today.
I do get that.
See, I'm hoping to educate 20-something people so that at least the situation will sound like when you hear the next time something
Right.
comes down the pipe, you say, you know what, I don't know if this works, but I remember that I heard this guy talking and maybe this is something that'll fit there. So why don't more people know about it? I mean, everyone has a different idea what bankruptcy is. Sometimes you hear bankruptcy, you think that means you have no money. No, it just means you owe more than you have. Your liabilities exceed your assets. You can't maintain them.
Just something to add to your point and to answer her question. There's different waiting periods for bankruptcy, foreclosure, and short sale for when someone can get into a new house if they need a mortgage. So it's worth people investigating, you know, I'm debating doing one of these three, which one should I do? And what are my options? And that'll answer their question about how long are the waiting period. will be.
They'll all have different, not to jump ahead to the question that I promise you I will get back to here. But yeah, each of those solutions has a different way it reflects on your credit report and on your credit score. So is one better from another? Everybody's different. We don't know until we look at that specific situation.
Just walking around my neighbor, walking the dog around my neighborhood, there's 2 houses. Both of them have been abandoned about the same amount of time.
Okay.
Both of them have, I guess, a tax notice or it's a statement that's right on, you know, on their front door or whatever. I never read it, gotten close enough to read it, but, and one is for sale and one is not for sale. Again, the same amount of time. So, and I know you don't know the individual situation,
Sure.
but is it just that the other bank didn't get around to
Probably.
trying to, or is there
Probably.
another reason maybe, or?
It could be any number of things. It could be the person who's moved out is frustrating the foreclosure process in court and slowing it down even though they've moved out. There could be a question of who holds the original note. You know, paper shifts so much. Until the 2007-2008 financial crisis, lenders were given a great deal of flexibility with the courts. If they didn't have the original paper, the original note, they were still allowed to foreclose anyway. And once everyone started getting foreclosed, that's when judges started putting a little more scrutiny on, show me the paperwork. And defense attorneys would step up and say, show me the paperwork that says you're authorized to foreclose. And that slowed down a lot of things because there was a lot of paper transferred electronically and no one had the original note. And as banks went out of business, it became harder and harder to track those down.
Now,
So-
can you go, where, to the municipal building in your town and find out the situation on the one that's not for sale?
Well, the municipal building in town probably wouldn't have much information on that because foreclosure is done at the county level. You can go to the county court system
Okay.
and find out then if that property's in foreclosure. Yes, you could. That you could.
If timing isn't an issue, how common is it that an institution would accept, let's say, a deed in lieu of foreclosure?
The question was, if there's no timing issue, how common is it that a deed in lieu is accepted? My experience is not that common. In order to do a deed in lieu, oftentimes you probably had to try to market and sell the property. There has to be some verifiable proof that you can't realize sale proceeds in some way. It'll be the same with a short sale. You know, you have to have something listed for a period of time. You can't say, hey, by the way, I haven't tried to sell the property, but would you accept 70 cents on the dollar? And we'll get to short sales in a little bit. After I've answered your question, I said, oh, sure. Yeah, so that's the thing.
So you have to show marketability and that you're not going to recover a good percentage of.
Generally, yeah, and even then, for reasons that they don't have to give, they may still decline the opportunity to accept a deed in lieu. And understand something, it's advantageous in many cases for the lender not to accept a deed in lieu, because they have benefits from foreclosing they don't get in the deed in lieu. When you foreclose out the rights of everybody who's a subordinate lien holder. That could be a second mortgage, that could be judgments that you do or don't yet know about, it could be the rights of any cohabitants, possessory interests, etc. That's all foreclosed out with a court order. If you accept the deed in lieu, you just say, I own the property. I also own the property now with all the headaches that I just explained. Those are your problems. So the deed in lieu will generally only be accepted in a situation where the lender has done some due diligence and realized there are no other judgments, there is no second mortgage, the person's already moved out, we verify that there's no tenants in there, et cetera, et cetera, et cetera. So deed in lieus are great from our perspective. If we're the homeowner, we're looking to get rid of the property. The banks usually don't do that. So, clients file for bankruptcy. Will they be able to get a loan to buy another house? Yes, they will. Now, they may pay a slightly higher interest rate because they have a slightly lower credit score. And if they have income to repay a new loan, that's going to be their determining factor on whether they will get one. Now, something key to know, Chapter 7, you file for Chapter 7 bankruptcy relief, you can't file again for another 8 years. You have no debt, and you can't file again for 8 years. So why will someone get credit? Because all of a sudden, you're a much better credit risk than you were just a couple months ago. You've left all your bad debt behind. I know you can't file on me again for 8 more years. And what I tell every bankruptcy client that I have, and they all laugh at me until 2 weeks after they file, and they come back and call me and say, you were right. As soon as you file for bankruptcy, a week later, you will be inundated with credit card applications. Because all of a sudden, again, you're a great credit risk. You can't discharge my debt for another 8 years.
Only in chapter 7.
Well, yes, you can't do another chapter 7 for 8 years. You can do another chapter 13 or a chapter 11, but the 8-year restriction is chapter 7 specific. But so if someone completes a chapter 13 case, and they come out at the end of it and some other parade of horribles has happened, they can file another chapter 13. But the reason for that is 13 and 11, remember, are reorganization bankruptcies. So your creditors have been paid something. And in chapter 7, you're just walking away. So that's why there's a gap of 7 years. Excuse me, of 8 years. Now, just a fun little side fact for bar trivia. That number 8 years used to be 7 years, and it was 7 years because in the Old Testament, the New Testament, the Quran, and any number of historical, biblical documents, the idea of debt forgiveness was that you should have forgiven debts every 7 years. It's in Deuteronomy, it's in any number of chapters. If anyone wants to ask me afterwards, I'll show you the citations. Scott?
So echoing what Luke said, you should speak to your lender because there are waiting periods. So yes, you're free of debt, but if you walk into a lender saying, yeah, I just completed chapter 7 yesterday, you're not going to get anywhere real fast. So
Yes, and it is specific, and I appreciate you pointing that out, but let's take this hypothetical. Let's take someone who lost their job for a year, fell behind on the mortgage, got a new job, but just can't get a loan mod, can't afford the house, whatever. They're going to surrender the house. They file Chapter 7 and move on, but have steady income. They're someone who might be able to qualify. Maybe it's not with you guys, but with somebody will lend them money.
well, there are some, I'll call them niche programs that do
Yes.
allow generally a year out of Chapter 7. So day one, probably not unless you're like really willing to find a hard money lender and you've got a lot of equity. But again,
Sure.
it's real niche. But the Fannie and Freddie stuff, there are set waiting periods. Absolutely. It's
Sure.
much harder until you achieve those.
I'm not saying it's as easy if you haven't filed. Certainly, bankruptcy is a last resort option. I never advise a client to file a bankruptcy unless they have no other choice. But it's just an option that exists where someone may have none other.
Can someone file bankruptcy if they have a retirement fund?
Can someone file bankruptcy with a retirement fund? Absolutely. Under New Jersey law, that is not part of the bankruptcy estate. So if you have a 401k or a 529 or anything like that you've invested that money, as long as it's an ERISA protected plan, that's not subject to attachment by your creditors. Social Security income, things like that, that doesn't have to be surrendered as part of the bankruptcy. Alimony is not dischargeable in the bankruptcy. So if someone owed the money, they still owe the money.
When you're saying they can't touch the 401k, but what happens if you're at that age and you're collecting on it? Can they take a percentage of what you're collecting?
Nope. No, they cannot. Question was, they can't touch the 401k account, but if you actually take that money, can they touch it? No, they cannot. Same way they can't take Social Security, same idea.
Who's paying that mortgage?
Who's paying the mortgage? If you walk away from the property and discharge it, the bank's going to foreclose and try and own the property and resell it to recoup as much as they can, but it's the bank's loss.
Okay.
And it's a write-off on the bank's end. No one's going to pay that mortgage. So, speaking of which, that leads nicely into our next section, which is REO. What's an REO property? REO is a real estate owned property. Okay, this is what happens when banks buy back the house at foreclosure. They've gone through their mortgage foreclosure, they bought it back. Now, why do they often buy the properties back? To protect their asset? Well, they're able to do it because of their ability to do what's called a credit bid. For those who aren't familiar with credit bid, if I have a house in Waldwick here, and I'm the lender, and I have a $550,000 loan, and I'm foreclosing, my bid that I put for that property in sheriff's sale is $550,000, but I don't have to put that cash actually down, because I've got a lien on the property in that amount. So I put down $100 with the sheriff and say, I'm credit bidding up to $550. If someone wants to outbid me, they can come up with $550 and one, and the bidding starts there. So, most often, we find foreclosures in situations where there is no equity in the property. So the first priority lender, who's likely the party that's foreclosing, just has to credit bid, and they're buying that back in foreclosure. And keep in mind, if this is a defaulted mortgage and it's been in foreclosure for anywhere from 8 to 24 months or longer, they probably also advance taxes during that time. And I don't need to tell anyone here, real estate taxes are not cheap in New Jersey. So you can add another, $30,000, depending on the location and the size of the house, to the, the amount on their lien. Attorney's fees, all that stuff, that all gets built into the breakup fee. So what they're credit bidding is a number that most people won't meet privately, which is why you have a lot of situations of banks buying back the property in foreclosure to recoup as much of their investment as they can. Their idea is then to turn it around and resell it. But the dirty little secret of bank foreclosures is banks hate owning properties. You'll hear sometimes that people get angry, and I have clients coming in for bankruptcy. Oh, this bank, they just can't wait to own my property. No, I've worked for banks for 15 years. They do not want to own your property. They want a performing loan. They want you to make that mortgage payment. And if you pay it late, that's what they really want, because I'll get you for the late fee. But that's the best case situation for the bank. They do not want to own the property, okay? They do not want the liability that comes with owning the property, the carrying costs that come with owning the property, and they're not equipped to manage that property. You think Bank of America is equipped to maintain a foreclosed house in Waldwick? No. That's not what they want to do. They want you to take care of yourself and have a performing loan. Now, this could present an opportunity for the right kind of purchaser. Not for everybody, but for some people, an REO could be a good prospect. So what do we want to keep in mind with REO properties? First of all, this is a strict as-is purchase. There is not going to be an attorney review period. There is not going to be negotiation on anything but a sale price that the bank says okay to. You are not going to get flexibility on any of the terms or conditions. This is strictly as is, okay? And the banks are going to be very inflexible on a lot of these terms. They may or may not even give you an opportunity to conduct an inspection. If they do, you should obviously make sure your client does it. But some banks say, listen, you can find out everything you want from public record about the status of the house financially. I'm giving you clear title. You can see the property from the outside. When you buy it, you can check out the inside. Now, that may sound like a dangerous proposition, but listen, we all have clients sometimes that like a house, like a property, think they're getting a deal and want to buy it anyway. But if you can do an inspection, you should. If not, understand the as is. Your client can't come to you after sale and say, hey, I finally went inside and hey, it turns out they poured cement in the toilet. Can I go to the bank and get that? No, you can't. That's your house. Enjoy the chipping away. Depending on the situation and the timing of the acquisition, you may also need to evict your prior owners. Okay, now we talked about this a little bit before. An REO situation just says, I have title to the property if you're the bank, and I'm selling you, that right to own it. If someone else is on that property, you can now foreclose. If you intend to live in the property, you have a little bit better rights than waiting until the end of the lease. At that point, you can give them the 90-day notice. But you're still going to have to evict them. And by the way, giving them a notice says get out in 90 days does not mean they're getting out in 90 days if they don't want to go. Right? They can avail themselves of the bankruptcy process and that automatic stay. That works both ways. They can avail themselves of the court system with an order to show cause and say, hey, I need another few months because X, Y, Z, I have no other place to go. My dog is sick. My kid wants to finish the school year. Solar flares. Yeah, what else? So what else should you know when you're purchasing an REO property? Okay, it's vitally important that the buyer does all possible due diligence before they make a bid. Don't have them go down the road and say, hey, you know what? We're about to close tomorrow. Did we ever do that tax search? That should be done before you're putting in your money. Know what you are buying. Work with a knowledgeable attorney and a knowledgeable title company who will order and review the proper things. You want to order a chancery abstract and you want a certified tax search. I can't tell you how many people try to do REOs, purchases on their own. They think they're clever and they go to a title company and ask for, let's say, a prior owner search or just a lien search or something like that. That tells you nothing about the actual foreclosure. You want the chancery abstract, you can actually look over the foreclosure pleadings and have a double set of eyes to make sure that the bank who foreclosed did it right. Because guess what, if they didn't, the old borrower can still step in and challenge, or someone else might be able to challenge that foreclosure. And you're stuck in the middle. Question?
Do you know how much these cost on average, to do this abstract title search and this tax search?
Let's turn around and ask Chris. Chris, what is Simplicity Sorry Wake Up?
Yeah, so really what happens is most title companies, they don't make money on the search. That automatically goes to the search company that's in the courthouse. So let's say a present owner, you just want to search what liens or judgments are on the current property on the state level. That would run about $105 to $150. If you want to do a full search, but you want to go back maybe 60 years, go back a little further, and you want to have the title company review and actually flag or red alert some of the items that are come back in that search, you're talking it might run about $300. But on average, for any type of liens judgments, you're probably looking on a present owner around $150, which isn't that bad on the state level.
Yeah. And so for several $100s, you're doing really great due diligence into a property that someone's about to plunk $400,000 or more on, right? Do it. do it. I mean, we all experience this when we have buyers on properties who want to cheap out on the inspections, right? Why do I pay $100 for a tank sweep? Because if you don't, you're going to own a property with an oil spill in the ground, and that's your problem after closing. So invest a couple dollars and do that work up front. Then depending on the timing of the acquisition, you may need to get the deed delivered through the sheriff's office. That doesn't really change how you approach your role in this, just something to know that if you're buying it from the bank very soon after the closing, maybe you wait for the bank to foreclose out. Remember we talked earlier about you can buy the bank's position, buy the note and foreclose yourself. You don't want to do that. You want to wait for them to finish the foreclosure. You can wait for them to finish the foreclosure and then buy the property from them where they would be the title owner, and they basically assign you the winning bid at foreclosure. And the sheriff would give you the deed at that point. Question? Oh, sorry. So, moving on to short sales. What's a short sale? As we discussed before, very simply, you're selling a property with liens on the property greater than 100, that the lien holders have to agree to accept less than 100% of the liens that they currently hold on the property. Basically, there's not enough net proceeds to pay everyone. And by the way, let's never forget that everyone includes your fees, my fees, and if you're the seller, the realty transfer fee. Okay, many times when we're calculating, we're just looking at mortgages, we're not looking at everything else that
So
comes
who's
with it.
paying those? Who's paying this?
Seller.
The seller.
The seller. So that's why you're determining whether or not you have a short sale situation, right? What is the seller going to owe at closing? If all you've asked your client is, what are the mortgages on the property? What are the liens on the mortgage lien? You haven't factored in everything else. You don't know if there's a short sale. And I know I bumped into that situation more than once, and maybe others have as well, where someone didn't advertise a short sale, but they didn't crunch the numbers. And then you realize that the number that they accepted and went to contract on won't pay off everybody once you factor in all those other charges. Okay? So, what can a short sale be? What kind of liens? They can be mortgage liens, they can be tax and sewer liens, they can be condo association liens, or like I said before, they can also just be judgment creditors. It doesn't have to be a lien levied on the house. When you're doing a judgment search, you have to do your affidavit of title that the person's not you. But if it comes back and that is your judgment, that has to be satisfied through the sale. You're not closing. That becomes a short sale. And if all you're looking at, again, is whatever the mortgage loans are, you're not looking at the full picture. So, my plea to listing agents, and this is something that I can't tell enough to every realtor that I speak to, it is incumbent upon you as the listing agent to properly determine all the outstanding liens and the debts that you need to be addressed through a closing before the house is listed on the MLS, and certainly before you accept the bid on that house. If you don't know what your breaking point number is, then I submit to you, I don't think you've done the proper job for your client. And you're leading them down a path where it could really, really backfire, depending on how the rider language works. I know if you have me on the other side, there's a representation in there, that attorney review, that you have sufficient proceeds to pay off all of those liens. And if you don't, you're going to be paying some money to my buyer.
I've had some people actually say they weren't aware that, say they were short by $10,000 or $15,000 or $20,000, that they could actually take that out of savings and bring it to closing and not be short.
Sure.
They thought it all had to come from the sale of the house.
Okay. Yeah. The comment that was made was that some people don't realize you can use personal savings to pay off. It doesn't all have to come for the house. Absolutely true. Absolutely true you can. But, I mean, that's infrequent. I see that a lot less than people just not realizing how much they actually owed when it comes to it. If you have someone who's selling a short sale, odds are they don't have that $10,000 just sitting around in savings and checking waiting to be spent.
As the listing agent, how do you know that, how can the listing agent, or what should the listing agent do specifically to find out what all these liens really are? Because I don't think my client's going to tell me maybe the truth.
Can you see my next slide? I think.
I can't, no, I can't see it.
The question was, what can the listing agent actually do to verify these numbers? Well, here's what you can do. To start, use the old Ronald Reagan line, you want to trust but verify, right? Consider obtaining lien and judgment searches. I've said before, all the realtors in here, you have people in your office, you have title companies that are referrals, or if not, again, take Chris's card. When you're sitting down with someone, find out, get a specific list from your client, what do you believe the liens are on this property? Then, trust but verify. Get a title rundown. Get a lien search. Get a judgment search for those people. Work with your in-house title company. If you do this as maybe they'll give you a discount on it if you're working your whole agency doing this in bulk every time you list the property. Get that information. Now, a lien search will only tell you who the lien holders are, but you know what you find sometimes? Someone forgets they had a second mortgage. Someone forget they had a home equity line. Okay, was there anything outstanding on that line? You find out information that you didn't have if you just ask the client, hey, you know, what do you think you owe? Sometimes people genuinely don't know there's a judgment against them. It happens. You know, the creditor doesn't serve properly, and they didn't know that there's a judgment out there against them, right? We find this out in advance by doing our due diligence, which is getting the lien search and the judgment search. And again, sit down, crunch the numbers, know what the situation is. When you know what your mortgage liens are, have your client call and get a payoff letter. Ask them for the most recent mortgage coupon that they have, the most recent payment stub, because that will have a good idea, at least a range of what the payoff number is. Now, it won't have all the information, and you want to request it ideally from the lender, because the lender has fees that they don't put into that regular payoff on the mortgage statement. So now, if we're certain that we have a short sale situation, what can the seller and the listing agent do to assist the sale? Many banks are requiring a contract of sale to be in, a contract for sale to be in place before they'll even evaluate the short sale request. You can find out in advance if that's going to be the case, because it lets everybody involved in the transaction know, okay, so, you know, what do we need to do to get this thing processed, okay? The next problem becomes if there's more than one mortgage lien on the property, it is highly unlikely the subordinate lender will release their lien without a small payment. But, here's the catch-22, it is even more unlikely that if you pay something to the second lien holder, that the first lien holder is going to release their lien if they're not getting 100 cents on the dollar. And therein goes the catch-22 of short sales. This is something we can find out very early on, okay? Even before we list the property on the MLS, there is nothing to say that the seller and or their agent couldn't reach out to their second lien holder and say, listen, I'm in a situation where I think this may be a short sale. I've had the property on the MLS, or about to put on the MLS, but based on comps in the area, I don't think I can recoup enough. You know, what do we have to do? Would you accept less than 100 cents on the dollar? And if they say our policy, our bank policy, we need 10%, otherwise we don't agree to it, then you go to your first, you crunch the numbers and find out, am I paying off the first mortgage entirely? Because if I'm not, you're going to run into that situation. I have to say, in 15 years, I have yet to see a situation, a single short sale situation, where a first mortgage company agreed to take less than 100 cents on the dollar if there's a subordinate lien holder getting even 1 penny. That's usually where they'll dig their foot in the ground. If the first lien holder is the only one getting paid, they may accept less than 100 cents on the dollar. But they're not going to accept less money to the benefit of someone else who's in a weaker position. Because in their mind, I might as well just foreclose that person out and pay them nothing anyway. So, if there are money judgments against the property, another thing you can do if you're the seller or listing agent is be proactive about having the seller or their attorney reach out to those judgment holders and see if they would accept a compromise amount. It's not uncommon that someone will accept less than 100 cents on the dollar, especially if you're paying them in a lump sum. But it's really good to know in advance whether or not that's the case. And you can do that by
Can we talk to the bank? Should we talk to the bank?
Can you talk to the bank? Well, the bank won't talk to you unless the client gives you strict permission.
How do I get the permission?
The client will have to call the bank and they'll probably have a form that authorizes you to speak to them. But the client can do that as well, okay? But what I'm contemplating here, with the money judgment, you can talk to anybody there, because what you're probably talking to is the law firm that filed the lawsuit and got the judgment against your client. Them you can talk to. You can call up and say, listen, I'm the realtor for this person, I mean, the seller can do this themselves, or they can go to an attorney who can do this for them. But you can certainly try to contact the law firm and say, listen, you know, what would your client accept in full settlement of this if we were to pay in a lump sum? And find out what the compromise is. It's not uncommon for people to sell for 50 or 60 cents on the dollar.
Even before we put the house on the market?
I would, because here's what I go back to it for. Let's say you don't do that before you put the house on the market. Do you know how much you can sell the house for?
Well, I do a CMA.
You really
You don't know
don't.
exactly.
You don't know. You don't know. I mean, and that becomes part of the problem, is you have to pay off these liens at closing if you're going to convey free and clear title. So what you're doing by not doing this in advance is putting your client in the position, and their attorney in the position, and the buyers and their attorney in the position of doing all this work to get to closing to find out you can't close. And I'm saying a lot of that is avoidable by being proactive.
Is it better to have the attorneys discussing this together?
Is it better, you're asking an attorney if it's better to have the attorney. It's always better to have the attorney.
Okay, in other words, what is the optimum role of the realtor in this as opposed to,
Okay.
in terms of
The
negotiating?
optimal, from the attorney's perspective,
Yes,
the optimal role for you is what I went back to a couple slides ago and asking you to do the due diligence in advance to find out what's actually the breaking point on a short sale.
Right.
If you've done that, you've done everything I could reasonably expect you to do before it hits my desk. Because then at that point, everything within your control, you've found out. Now, if something springs up, a judgment that didn't come up on the judgment search for some strange reason, or a judgment that was filed after the judgment search was done, that happens too, right? The reason we freeze out home equity lines prior to closing is because you don't want someone borrowing against it the day before closing. So you freeze it out a few weeks, you close the account a few weeks in advance.
So this should be done by the attorneys.
This part, I suggest, is probably best done by the attorneys.
Thank you.
But you will have, sometimes sellers don't want to pay an attorney to do it. Attorneys don't do this for free. This is not part of my flat fee on a closing. If you want me to do something like this, you're asking me to go above and beyond the normal situation. And there has to be some sort of fee arrangement to be done there. And every attorney will be different. Maybe you find an attorney that's willing to throw that in. But depending on how many judgments, if it's one judgment, maybe I'll do it and put a call out and see what we can get back. But let's face it, you're generally not even bringing the attorney in until you've already got the contract signed and you're moving towards attorney review. I'm suggesting this be done in advance to the best you can to find out what your short sale number is.
Would the realtor have any liability? They do the work here and mess up by $5,000
Will
worth.
the realtor have liability? They might. I'm not suggesting they won't, but what I can suggest is if the realtor did no due diligence whatsoever, and then, oh my God, it's a short sale, we can't close, and the client, the seller, they're going to plead ignorance. Well, I rely on you to figure this out. So I would always argue that having proof that you've done some due diligence is better than showing you've done no due diligence. There's no guarantees. Lots of the law is a gray area, right? There's nothing in the law that is black and white. If I ask you right now, is it illegal to kill somebody? You say, of course it is. And then if I give you the fact pattern, someone was coming after me with a knife and I slammed his head into the wall and killed him, that's legally defensible, right? So I can kill somebody legally. There is no black and white. It's a whole lot of gray.
Do you get paid, do you as an attorney?
Hopefully.
Right. All right, no, hear me out.
Okay.
Okay, so I have somebody and I do my best due diligence, however I say to them, look, it would be my recommendation that you hire the attorney to proceed with further due diligence and pay them for their time to do this so that we can make sure the sale happens.
Okay.
Will you get paid in this situation?
When do we get the attorney involved? Consider this, and again, there's no absolutes here. I'm just giving you my best practice opinion. Sit down with your client, figure out the numbers you can control, what the judgments are, what the mortgage liens are, if there's any tax obligation, what those are. Figure out your number. You're doing the comps to figure out what you think you would list it on the MLS. Based on that comp, you can figure out the realty transfer fee, you can estimate the attorney fee, you know what the commissions are going to be. Put all those numbers together. That gives you the best idea of where you're starting from. If the numbers are going to be close, then you can tell your client, listen, we may want to retain an attorney to see if we can do something on the back end with these judgments so that we don't have to worry about short sale. I think there's a lot of that work that can be done by the realtors before you get to an attorney needing to do this, depending on how everything else breaks down. I mean, listen, there could be someone with hundreds of thousands of dollars of equity that just has a couple of judgments on the back end. Doesn't mean it's a short sale, right? So you don't have to rush out just because there is a judgment, get the attorney from the beginning. Part of the due diligence that I'm suggesting be done is you guys putting together all the information you can get and get a real good idea of what that breaking point number is. Yes.
From the buyer's side, I'm
Yes.
representing a buyer who's going in and
Yes.
considering this. And all the short sale paperwork, it all hasn't been filed yet,
Mhm.
okay? So I say to the listing agent, well, do you know that if there's a number that will make this not a short sale?
Yes.
How do I know that that number is gonna really be the number?
You don't until we get closer to closing, certainly, and those are going to float. But you're making the representation, and the attorney for the buyer would put into that rider, hopefully, that the representation that this is not a short sale. And that's why you always want to know your breaking number, because you have to advertise this as a short sale if it's a short sale.
Okay.
You have to be forthright with your buyer's agent that this is a short sale. You think they're going to want?
Should we put this in the listing?
If you know it's a short sale, absolutely you have to. But my point is, sometimes things are so borderline, or if you get a number that's just below, and you don't know. But if you know in your head, listen, my break number here is 400,000. Anything below that, we're going short sale. When somebody offers you 395, you say, listen, I'm obligated to take it to my client, but just so you know, at 395, this is probably going to be a short sale. Put them on notice, communicate openly with them, and let them understand the ramifications that come with that. That's you having done your job as a listing agent correctly.
And
in my
let's say
opinion.
the bank accepts this,
Yes,
who's paying the commission?
that would come out of the short sale. That's what's called the carve out. Hold that thought, we are gonna get to that in a second, yes.
If somebody has judgments against them and they go through the short sale and the company or the entity, whoever, who issued a judgment against them didn't get paid,
Mhm.
can they try to get it from them again in the future?
Say that again.
So say a plumber has
Yeah.
a $20,000 judgment against somebody,
Yeah.
and through the whole short sale process, it goes through,
Mhm.
and the plumber got nothing.
Mhm.
So
Well,
can they
well,
try
why
to
did
put
he get
judgment
nothing
against-
for what reason? Because he wasn't found in the judgment search?
No, there wasn't enough money in the proceeds.
Well, then you can't, but his lien attaches to the property. The buyer at that point is either buying the property subject to his lien, or is insisting that that lien be taken care of as part of the closing process, which goes back to talking to the seller, to the judgment holder in advance, to say, would you accept less than 20,000? If I gave you $5,000, would you release your lien? That has to be done on a case-by-case basis on that money judgment.
So
You don't just get to close and ignore that debt. That debt travels with that property. It is in rem, not in persona. It travels with the property, not the person.
If the plumber got stiffed completely, can they try to issue another judgment against that person again in the future?
Oh,
Because they still owe them money.
Against the original.
so if you're saying it's already, if he said, okay, yeah, I'll take the 5,
Well,
and
they
later,
didn't get anything, and they said, no, I want my
well, why would he
20,000.
get
But
nothing?
then,
My question
Hang on,
is,
hang on.
my question leads to, should they have done a bankruptcy and wiped out those judgments, and then go through
in
the
certain
short sale?
circumstances, yes. It's tough to give a broad yes or no because there's a lot of intangibles and whether a bankruptcy is the appropriate remedy,
Right.
but possibly.
I'm saying,
possibly.
not the judgment, because that's a legal thing, but can the debt chase them down later and the plumber go after them again?
Well, the
In the
debt is the
next house.
judgment. Those are synonymous. The question is whether that judgment's been reduced to a lien
Mhm.
on the property. That's sort of the secondary issue. But you're asking about the obligation to pay.
Right.
That obligation to pay will always be there with the person, but it certainly could be a lien on the property. And again, no title company, no competent title company, Chris, for example, will not give a clear title
Right.
to a buyer if that judgment has not been satisfied in some way. If it's not 100 cents on the dollar, it's something less than that, that the holder is signing a document that says, I agree to accept 5,000 in full settlement, releases, etc.
Okay.
So that doesn't usually slip by unless there's a really, really sloppy title company, or unless something just didn't come up in the search for some weird
So
reason.
even if the plumber's not gonna get anything, in order for this to go through, he still has to give up the judgment and the lien.
Or you can stand firm and he can put a wrinkle in your machine. A wrench in the machine is probably the better analogy.
Quite often, George, sometimes it could be a mechanic's lien. He's talking about a plumber, but it could be a kitchen that was done
If
prior.
it's a mechanic's lien, but that becomes a lien, he's talking about the debt obligation. If it's a lien, you're still not closing,
Well,
because you gotta get a lien
point
that's
of all
going
that was, should
unsatisfied.
they, would your recommendation be go through the bankruptcy, get rid of those so it can't follow you?
Possibly.
Thank you.
I wouldn't file a bankruptcy just for one lien.
Or seven.
If there, but that's the real question, is balancing the whole situation, the totality of it. How many liens are there? How much of a short sale is this? If we're talking about a short sale of 5 to 10,000, and you've got a couple of contractors with $20,000 judgments, talk to the contractors about taking, 5,000 to go away. It's still a better situation than a bankruptcy at that point. But it's a subjective thing. You got to look on a case-by-case basis. Yes.
Going back to what you said before about listing a house for 400, it's okay, and then 395, it becomes a short sale.
Yes.
Legally, we list it 400, and don't say anything, and then the buyer's agent comes in at 395. Verbally we tell them, or do you have to put this in
I
the
think you
listing
have to say it's
somehow?
a potential.
How do you do this to protect the listing agent?
Potential.
Yeah, I think what the question was, what happens if what's the proper mechanism by advising your adversary that this could potentially be a short sale? I think everyone heard Deb. You advise them orally that this could potentially be a short sale.
And I think you put it in the listing.
You would change the listing at that
I
point?
would absolutely put it in the listing,
Okay.
because you want it out there that there's a potential that if we don't get the right number, there is a potential for this to be a short sale.
You see it pretty commonly, potential
Or
short
potential
a
short sale,
possible short sale.
Yeah.
What I would say generally, you will get in less trouble, broadly speaking, in many aspects of life, by going above and beyond to disclose than in asking for, forgiveness down the road.
One quick question on the short sale. I have a situation with a buyer who may buy a property. The listing agent has already told me they're underwater, but
Yes.
it's not going to be a short sale. They have enough to bring to closing.
Okay.
As the buyer's agent, what other due diligence do you do to make sure it doesn't actually turn into a short sale?
Great question. What does the buyer's agent do if a listing agent makes the representation that this is potentially a short sale, but but the buyers have enough cash so that it doesn't have to function as a short sale. The best thing you can do is advise your client openly from the beginning that this is the risk that they're going to enter if for some reason that person is misrepresenting their cash. I don't think if you had a cash deal, you would ask for verification, a proof of income, proof of amount, cash flow, whatever. Get that. See, make sure that they actually are holding 20 or 30 or 40,000. I can pay off those liens.
Would you do that in the attorney review process?
I would suggest you do that before you actually sign the contract, because I think the buyer would have to understand what they're walking into before they sign that.
Okay.
You know, a concept, before you can have a valid binding contract in any state in the U.S. under U.S. law, you have to have what's called a meeting of the minds, right? If you don't have a meeting of the minds, there is no agreement on terms, there is no contract. If you don't exactly know what you're buying or how you're buying it, I would argue there is no meeting of the minds. So in that sense, I would suggest that you have a conversation with your client that this could be a short sale, and maybe get some disclosures from the seller up front. Give me a breakdown of what you think is due and owing. How do you quantify what is remaining due? Show me a payoff letter. Show me that you have, you know, proof of income or proof of funds, and see what they come back with. I don't think you're out of bounds to ask for any of that as the buyer's agent. And then again, last option, consider a bankruptcy. So, if we're certain we have a short sale, what can the buyers and buyer's agent do? Again, communication is the key. I think the buyers have to be aware that they may be expected to wait a long period of time before you get short sale approval. Remember, my sister a few years ago was looking to buy a short sale house, waited a whole fiscal quarter. Chase never got back to them at all. She just walked away from the deal. But be upfront with them that this could be months, because there is no deadline. There's no way to enforce it. There's no statute that gives you rights as a potential buyer. And you also have to understand, from the buyer's perspective, that many sellers' attorneys are going to insist that you go through attorney review before that contract is submitted to the bank for approval. Why is that? Because it's a lot of work for a seller's attorney sometimes to get the bank approval. You're spending months, in some cases, following up and trying to get it. And the last thing you want is to then go to attorney review and find out there's some stupid inspection issue that your buyers no longer want the house. You want to take all of those issues off the table. If I'm going to invest the time as the seller's attorney in getting this short sale approved, I'm going to make sure we have a deal.
So you're actually going beyond attorney review to the inspection contingency part?
Yes.
The inspection.
Oh, absolutely. Absolutely. But I would have, the question was, when I go past attorney review and do inspection, I would actually do a modification on that. I do sort of what they do in New York, which is you do your inspections up front, and we're building that into attorney review. You're going to get all your inspections done. You're going to tell me what you want. If there's any request for remediation, we're going to tell you yay or nay. And when we have agreement on all of that, then we're putting it into a contract with riders and submitting it to the bank. Because I'm not undertaking months and months and months of work that will go unpaid just to find out that, hey, you don't like the upstairs hallway painted pink.
Yeah, but what would happen if it takes 8 months, certain things happen to the house between first inspection and actually getting to that point where you've got an agreement from the bank to buy that house?
Great question.
Those people could still be living in that house now, stripping
walls.
copper and.
Absolutely. The question becomes, what happens in the intervening period when you're waiting for short sale approval? What I would suggest is that the contract has to be specifically languaged to say that the way in which I see the house during my inspection is how I expect it to be delivered. And any obligation to make it and keep it that way, aside from general wear and tear, is the responsibility of the seller.
And then
And if the seller fails to do it, then you get to cancel the contract and get your money back as the buyer. So, both sides need to ensure that the attorneys handling the short sale are dedicated and experienced real estate attorneys. I often find out in real estate sometimes someone has an Uncle Charlie who does, estates planning and wills, and hey, so, the family member's got a closing, so we can do a closing, right? And we do a closing. Don't get Uncle Charlie involved on something like this. This is above Uncle Charlie's pay grade. It really is. And some of these niche things, you really do need someone experienced in these areas. And do your best. And obviously, look, we all understand our clients make decisions that go against what we recommend. Often, we do what we can to sort of advise them that, look, this is why you can't use Uncle Charlie. So moving on to the New Jersey Bulk Sales Act. Okay, it's a law, a state law that was really updated in 2007, originally enacted in 1995. What this effectively does is it requires parties in a transaction to notify the New Jersey Division of Taxation if there are certain transfers of property, so the division can determine if there's any outstanding tax liability. And they would take their taxes that were due and owing from that sale, from that transfer, and recoup it. The obligation here is on the buyer to file the required paperwork at least 10 days prior to the closing. So, what is the Bulk Sales Act and how does it function? This this is the relevant statute, if anyone really has trouble sleeping tonight. It applies to transactions involving the sale, transfer, or assignment in bulk of business assets, otherwise than those in the ordinary course of business. What does that mean? If I'm in the business of making baseballs, and I sell Joe a baseball, I do not need to file a bulk sales act because I'm in the business of selling baseballs. So I don't need to process that. If, however, I was to sell Joe my company, which manufactures baseballs, that's different. I'm not in the business, ordinary course of business, of selling a business that manufactures baseballs. So that's where the bulk sale would kick in. So how does that apply to real estate? Well, let's note that the sale, transfer, or assignment of a simple dwelling house, if the seller or assignor is an individual, an estate, or a trust, is exempt from the bulk sale. So, short and sweet in plain language, if you're selling a house and it's owned individually, not a corporate entity, if it's a trust selling it, or if it's an estate selling it. Aunt Ruthie passed away, we're selling her house. Those are exempt. You don't have to worry about the bulk sale in those situations. But it does apply to the sale, transfer, or assignment if a business entity is the one selling it. And I would remind everyone that in the form contract, there is a checkbox. It's like 14 or 15. There's a series with the POET system and everything else that rarely gets checked off. There is a bulk sale checkbox there for yes or no. So it's important that everyone know exactly when you should be checking yes and what you should be doing. It does not apply to a seasonal rental unit. You got a house down in Point Pleasant Beach, doesn't apply if the seller, again, is an individual estate or a trust, but if it is a business entity. Number 1 Happy Street LLC, Point Pleasant. That does have to file for the bulk sale tax. So the rule of thumb basically is, and as it applies to real estate, where your seller is an LLC, and it's usually a single asset LLC, you do have to check yes on the bulk sale, and you do have to make sure that your buyer is processing it. So, with that said, new construction. New construction is almost always done by an entity, a corporate entity, right? So, does the new construction LLC, do they have to file for bulk sale tax? No. Why? Because the ordinary course of business exemption applies to them. Their ordinary course of business is to build and sell houses or condominium units. So that's the exemption here. That is their ordinary course of business. Okay? So why is the buyer responsible for filing these forms? Because the lien will travel with the sold assets. So the seller does not care. Even if the seller if the selling company owed that tax liability, that liability and that tax lien will travel with the assets to the buyer. That's why it's incumbent upon your buyer to make sure that they are processing this correctly. And if you know that this is the situation in closing, you want to make sure that your buyer's agent is aware that this is a bulk sale situation. If Uncle Charlie, who doesn't know about the bulk sales application in real estate, you want to make sure that they're doing it. So be on the lookout for that, and always know when to check that box on the contract. So let's move on to HUD houses. What are HUD houses? Well, these are houses that government-insured mortgages have foreclosed. Freddie, Fannie, any other government-insured mortgage owned by the Housing and Urban Development, and they're looking to sell the property and recoup some money. Where can you find them? There used to be a number of sites. I know this is a little bit of blue on blue, but there used to be a number of sites where you track down HUD houses. Now, everything is listed on this HUD site right here. For those who can't see it, HUDHOMESTORE.com. So why would one buy a HUD house? Well, HUD houses tend to be low to moderately priced. If you have buyers, especially in this area, who just can't afford some of the higher end options, this may be a viable alternative for them. And it's also worth knowing that HUD covers most of the closing costs for these buyers. They will cover your commissions. They will cover a lot of the closing fees. They will cover the attorney's fee. So it's worth noting that people, again, who don't have the financial wherewithal, want to go back to that? I'm sorry, taking a picture. By the way, if anybody, I don't mind if people take, if anyone wants a copy of this PowerPoint, my computer broke this morning, I will email anyone if you want a copy of this. So, I was prepared to give you all handouts of it, but technology bit me on the hinds this morning. So, how is this process different from a regular closing? Well, the way a HUD transaction works is property are listed for a 30-day offer period. They're offered on that website that I posted a few minutes ago. A sealed bid is given with the earnest money deposit, which is usually 5%, and the buyers can cancel their offer without penalty until such time as those bids are actually opened at the end of the offering period. Buyers are strongly encouraged to do their inspection because much like an REO, that house is as is. You are getting it in the exact condition it is, even if that condition negatively is impacted between when you bid and when you buy, okay? Now, this is important for you all. Buyers must work with a realtor who's registered with HUD. If you are not so registered, I understand it's a fairly easy process. I don't know the specifics, but I know realtors who have registered for HUD, and it's not a laborious thing. So, Scott?
FHA allows those homes to go for $100 down on an FHA loan.
Okay.
So that's huge, if somebody's got limited money. Now, granted, most of, they're listed 3 ways on the HUD Home Store. I forget the exact codes, but basically inhabitable, might need some work, it definitely needs some work. So the might indefinitely will qualify you, or will most likely qualify for a renovation loan at 203K.
We're going to talk about that.
Yep, exactly. So they're really good cheap ins if you're willing to do the work.
And for first-time homeowners or people who are just lower income, so not everyone can afford, Upper Saddle River. We'd all like to, but not everyone can. And there are homes in this area that can qualify for that kind of a purchase. So, yes.
2 questions. The
Sure.
first is, how do you get into these homes? If they're vacant?
It's a great question. How do you get into the homes? There is a listing agent, and they will give you access.
Okay. And the second question is, if you have a buyer that does this as an investment purposes, can they buy?
Hold that thought. We're going to get to that in 1 second. Yes, with a twist.
Okay.
What I say is gray area, right? You can kill a person.
You
It's
sold
not
an
illegal.
investor and I sold a user.
If you take nothing away from this today, you can kill a person, and it's not always illegal. What did you learn at the RealSource seminar? But I can kill a person, and it's not necessarily illegal. All right, so HUD is transitioned. For anyone who hasn't done any HUD closings recently, they are transitioned, I think, fully now to e-signature sales packages. Everything is automated. Everything's going to be electronic now. All right. During the offer period, only all owner-occupied bids are allowed. Again, that's that 30-day offer period. At the end of the 30 days, all the bids are open. If there are any, the best and highest offer will get the bid. If after that initial period there are no bids, that's when investors can step in on the 31st day. And those bids are thereafter open daily. So you don't have to wait another 30 days. On day 31, if your investor does a bid, you'll know the morning of day 32. Okay? And if there are no bids after a while, if the house just sits there, HUD will very often lower an asking price. So if you're sort of monitoring and following a price, but your client doesn't hit their price point yet, you can try waiting it out. Now, the realtor will check the HUD website to see if your client's bid was accepted. That's how you'll know. No one's going to call you. So incumbent upon you to do that due diligence and find out for your client if their bid was accepted. If it was accepted, and you have to be on the ball with this, they must close that loan and that title within 45 days. That is a hard out. That is not subject to negotiation. That is not subject to extension. When we have real estate contracts, normally we have on or about dates. There is no on or about date. It's 45 days or your client's going to lose their EMD. And HUD used to do 60 days. They're down to 45. And from everything I understand, they're moving closer to 30. So you need to make sure your clients are motivated and ready to roll and have their ducks lined up before they go down this road. It is the responsibility of the buyer to get their own financing. If you buy an REO property and the bank owns that property, they're likely to offer you something from their finance department to, again, try to make some of their money back with interest over time. HUD offers no such programs. So, some tips and tricks for buying a HUD house. You want to consider, as Scott indicated a few minutes ago, an FHA 203K loan. If a house is depressed or is a fixer-upper, it gives the opportunity to get the loan and get some cash to invest in the property and make some modifications and updates. You can talk to your lender about that. Certainly talk to Scott afterwards. You can get financing lined up ahead of time. 45 days, again, very hard deadline. Don't just get the pre-approval letter. Make sure your lender's ready to rock with that.
Yeah, but on a 203, that's often such a long timeline, and it's dependent upon the home and the condition of the home. Are they going to be able to close it in 45 days?
Every lender is going to be different, but let's put it this way: every lender knows with that loan that it's basically for a HUD or this kind of property, and if they're willing to offer it, my guess is they will do it. They'll make it happen. But listen, go with lenders you trust and have those conversations in advance. Again, being proactive about, I've said that over and over about, to the agents in the room throughout this presentation. Always be proactive. If you have someone, if you're working with a lender that you've recommended to the client, have a conversation with that lender. We're buying a HUD home. We're going to have 45 days. Can you close this loan in 45 days? If they say, we think so, we're not sure, we'll look into it, maybe you'll find somebody else. Also, not inappropriate to ask them how many of those types of loans they actually do.
Yeah.
If it's not something that they do often, maybe that's not the right house for you. Now, the title company is going to pull the laboring oar in a lot of this process. So sort of like we talked about Uncle Charlie, don't use Uncle Charlie for the unique real estate situation. Don't use Aunt Edna and her title company if they don't do HUD work. You will have an attorney involved in the process, and they will sort of answer questions as you go along. But the laboring oar is certainly pulled by the title company. So make sure you have people that are experienced in that. And also be very aware that HUD uses asset managers to handle this transaction for the seller. These people are going to be out of state. They're going to be slow. They're going to be overworked. They're going to be non-responsive, like dealing with a government bureaucrat. All right? Be very proactive and out front of anything you need to get from them. Do not wait till the 11th hour on anything, or that sale is not going to happen. So, some more tips and tricks. You're going to need a couple of things, one from the lender and one from the municipality in order to process this loan. The first thing with the lender, you need what's called a delegation of authority letter. Now, this provides the authority for the asset manager to sign the closing documents. That's something that you will end up chasing the asset manager for. If you ask them very early in the process for that letter, you're building in enough time that they can get back to you and get it to the lender so the lender can clear to close. The lender probably will not issue their clear to close if you do not have that letter. So again, you're dealing with, if you're trying to get a loan closed quickly within 45 days, don't make the lender wait. Put it on them. The second thing is, and I've been advised that this started in February of this year and is New Jersey only, that HUD now requires a VPR letter. That's a vacant property fees letter from the municipality. That's a letter that will state, and it can be done through an OPA request and through working with the municipality, that states that there are no code violations, property violations, open permits, etc. on that particular property. Not every municipality will give you a letter on their municipal letterhead. Some of them will basically just give an OPA request, and that might be good enough. But by requesting this as early as you can with an OPA and by talking to the town, get it to the asset manager and find out if that's acceptable. And you'll do that again through the title company. So you want a title company that knows to expect this. But this is a newer thing for HUD houses in New Jersey. So moving on then to our last topic for the day is going to be something that's maybe unique here, very unique, in 1031 like-kind exchange. Now that's so named because it's section 1031 of the IRS code, and it allows an investor to defer paying capital gains taxes by swapping their property for another like-kind property. Now the term like-kind is a very broad term in many ways, but the properties must be of the same nature or character even if they differ in grade or quality. So what that means is I can trade a condo for a three-family house because they're both, let's say, depending on the ownership structure, they're both, living dwellings. What I can't do is trade a two-family house for a lawn tractor. That's not similar enough. For real estate purposes, almost any sort of property exchange is allowed, provided both properties are located in the U.S. Now, this can only happen with investment property or business property. This is not an available option for a primary residence. This is important to know because someone who, let's say, wants to relocate and not someone who lived in their house for 30 or 40 years, wants to relocate south, doesn't want to pay capital gains perhaps, or if they've accrued that much equity, would otherwise look into this. If it was set up properly as an investment property or business property, that would be different. But on primary residence, it won't work. Now, as part of the swap, the property and the loan amount need to be roughly the same, or the property required needs to be a little bit more. In other words, you can't trade a property for a less valuable property. And it must be the same taxpayer on both ends of that transaction, with the sole exception being if it's single-member LLC is giving up the property, they can reacquire another property as an individual, again, as long as it's the same individual that was the single member, because an LLC is basically a pass-through corporation. And our old friend, the bulk sale, pops in his head here. Again, if this is not your ordinary course of business and you're selling something owned by a corporate entity, the bulk sale does apply. Yes.
What does it mean when you say exception for single LLC, single member LLC? If it's the same LLC buying and selling?
It can be. Most people don't do that because most people will get an LLC registered in, let's say, a certain state.
Right.
So if I own a property in New Jersey, I buy it and it's New Jersey LLC. If I'm reacquiring a property in North Carolina, the odds are I would want an LLC down in North Carolina. The problem is, even if it has a similar name, you're not going to get the same tax ID number for that.
But what if it's the same state?
Could you swap it?
Yeah.
I believe that you can. I don't know of a restriction that you can't. We'll ask some people, but I'm pretty sure that you can. So there's basically 4 general types of 1031 exchanges. The most common one is called simultaneous exchange. That's where 2 or more parties will swap at the same table their properties. This is handled by what's called a qualified intermediary, who is a specialist in this. That intermediary will structure the deal and acts as a fiduciary for the money. There's also called the delayed exchange. Delayed exchange is you surrender your property and you have 45 days to identify what new property you are going to be acquiring as part of that swap. That's a hard 45 days. You have 180 days from when you give up your property to then complete that transaction. Once again, that is a hard 180 days. These are not flexible terms, so you want to work with people who know what they're doing, and you want to be proactive about the identification of those properties. There is a reverse exchange, in which you acquire the replacement property before you identify the property that you want to relinquish. The problem with that is, it basically buy first, pay later. The problem with that is, to the extent you may have to kick in any cash, banks generally will not lend on those deals because you are basically acquiring a property while still holding yours, and there's a lot of risk involved. So generally speaking, anyone who does this is going to be a cash buyer. And finally, you can do a construction improvement exchange, which takes the tax-deferred dollars held by the intermediary to make improvements on the replacement property within that 180-year window. So if you're dealing with property that needs work, you can get certain structures that will allow for money to be pulled out during that 180 days of work to be done. Now, I have besmirched the good name of Uncle Charlie repeatedly throughout this presentation in saying that don't let people do what they don't know how to do. And I will openly stipulate to you that I don't know, besides the concept of it, how to do a 1031 like-kind exchange. I've never done one. I'm not going to be a qualified intermediary. However, the three people sitting in the back of the room over here, Ed, Deborah, and Matt, do 1031 like-kind exchanges. They work for Stonecrest Partners in Ridgewood. I would encourage any of you who have any interest in learning more about this to meet them afterwards, take their cards, and talk to them. This is everything that I've spoken about today can be considered niche in some way within real estate. This is really niche. You will find some attorneys who do act as qualified intermediaries, but unlike an attorney acting as a settlement agent on a traditional closing, this is a whole different ballgame. So working with people who know exactly what they're doing is the recommended course of action. That is my prepared material. Does anyone have any questions? Anybody have any questions?
I want your card.
My cards, thank you for asking, are right outside by where you signed in.
Okay.
And on the back of the card, it has my areas of practice. If there's something that's not on there and you have a question, give me a call. Something I can't do, I might know somebody who does. I will gladly take all of your cards, absolutely.
If you take everybody's card, maybe you can just email.
I could do that, yeah. Whoever gives me a card, I will send a copy of this
That's
presentation.
it, right.
Well, thank you all for coming.
Thank you. Thanks, George.